Summit Saugatuck versus Westport. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. How we're handling this on this virtual platform is that when a justice has a question, they will either raise their little virtual hand, you see a little yellow hand in Teams, or you'll see the justice raising their hand before you. Once you see that hand, please get to the logical break point in your argument and pause so that I may ask the justice to ask their question. I'm assuming that you've both read the notice that we send out on how to handle these virtual presentations. So thank you very much, and I really appreciate you coming in and doing this argument virtually. This is the way we've been able to keep the courts going. And it's been a really interesting experiment, and some things that we're going to keep and some things we won't. But so far it's been very successful, and thanks in no small part to the bar. So thank you very much, gentlemen. With that, if you are ready to proceed, will the appellant please identify themselves for the record and let me know how much time, if any, they wish to reserve for rebuttal.
Thank you. Good morning. I'm attorney Tim Hollister, representing Summit Saugatuck, the plaintiff and appellant. On February 1st, I joined the Hartford office of Hinckley Allen. I'd like to reserve 5 minutes for rebuttal, and I would note that there is a labeled map that illustrates this case on page A177 of the appendix to my brief, if the court has not seen that.
Thank you very much, counsel. Senior Associate Justice McDonald will be our timekeeper. He'll let you know when there's 5 minutes, 3 minutes, and no time left remaining on your argument. With that, you may proceed.
Thank you. In summary, Summit Saugatuck asks this court for two rulings. The first is the General Statute 7246A gives Summit a right to appeal a denial of a sewer extension to the Superior Court, notwithstanding a so-called negative 824 report by the Planning and Zoning Commission, and notwithstanding a lack of reversal by the town's legislative body, and that is for three reasons. One, 7246A expressly says, notwithstanding any other provision of the general statutes, a denial is appealable. Second, 7246A is a later enacted and more specific statute than 824. And third, in 2003, in its Fort Trumbull decision, this court held that 824 reports are advisory, preliminary, and unappealable. Second, we ask, of course, that the appellate court decision be reversed. But in this case, somewhat unusually, it's because the bases of the appellate court decision have essentially been superseded, and that is shown by the fact that the WPCA in July of 2020, in its action on Summit's reapplication, essentially conceded that it has no remaining factual or policy basis to deny the extension, and its denial is based solely on its 824 position. And of course, the appellate court did not address the 824 issue. So with respect to the Summit's rights under 7246A versus the town's 824 claim, the WPCA essentially asserts that the Westport Planning and Zoning Commission's negative 824 report stops the sewer permit process under 7246A in its tracks unless and until the sewer extension applicant appeals the negative report to the representative town meeting and obtains a positive report. And the WPCA concedes that that action by the RTM is not appealable. So that would be the last word. But the WPCA's position is simply contrary to the text and the context of 7246A because of this notwithstanding language that I just mentioned. So our position basically is the text of 7246A is clear. It should be dispositive. 7246A grants the right to appeal, and 824 does not and cannot take that right away. In addition,
there's a question from Justice Kahn. Thank you.
Yes, Justice Kahn. Good morning.
Thank you, Chief Justice. Good morning, counsel. I have just two questions. One is, do you agree with the appellate court that the standard of review that the trial court should have used was the typical standard of review for an administrative appeal? In other words, was the agency decision arbitrary, capricious, in violation of law? Do you agree that that was the standard the trial judge had to use?
Yes.
And I understand your argument that the absence of having granted something conditionally doesn't amount to a policy of never granting something on a conditional basis. So I get that argument. And assuming you're correct, that there's no bar to granting something on a conditional basis, how is it arbitrary if there is a denial because for a particular project, there is a choice not to grant something on a conditional basis? How would that amount to being arbitrary and capricious? Do you see what I mean? Because there isn't an absolute policy that it's always that you can't deny something for a condition. Couldn't you still, on a case-by-case basis, say this condition here is too risky, particularly when it looks like the contractors for the project itself changed midway? Is my question clear enough?
Justice Khan, I didn't understand the last thing you said. The contractors changed there was no.
I thought early on there was one project, and then that project fell through, and another project was proposed that included 37 more units or something like that. I may be
No, okay, well that's true. It was still some at Saugatuck, and the immediate consensus with the WPCA that was a de minimis change. Right. There was maybe 8,000 more gallons of capacity, so that was essentially a non-issue. But first, I assume you understand that our position and the way this case has unfolded is that the policy has become essentially a moot point because the condition of completing the sewer upgrade is agreed by both sides to have been accomplished. It was finished in December 20. I do,
and that there are 5 new reasons. I understand that, but at the time the judge was reviewing this, that was still a basis for the denial. And when we review the trial court's decision, we have to review what the trial court based it on, don't we? When we review the appellate court's review of the trial court's decision.
Well, yes, except that, of course, the condition has been essentially satisfied, so that to reinstate or examine the trial court's decision based on a condition that has now been satisfied, I think was subsumed in the when the cert petitions were filed and reviewed. It was noted that the condition had been essentially superseded, and the issue before the court is just the 824 as the only basis for denial. Having said that, I would certainly agree conditions in land use cases are not mandatory except in the 830G affordable housing context, which is not before the court. But conditions are necessary and prudent for 2 reasons. Number one is they are used to eliminate the risk, such as of premature construction before you have all your permits in hand. And second, very importantly, they avoid a stalemate. If an applicant needs multiple permits to go forward with a project, conditions are the way to allow the permit applications to proceed simultaneously. Okay, you can construct your sewer or you can extend your sewer, but it's conditioned upon you getting zoning approval. So that was the thinking, which I think was correct, of Judge Schluger, which was if I make this conditional on construction not starting until all permits in hand and the sewer upgrade is done, then there's no risk to the town. At that point,
let me just ask you a different question then, and perhaps I'm confused. What's the current status? Have the additional 5 reasons given been, and maybe that's not an issue before us, but I'm wondering whether this whole thing is moot, whether the conditions have been satisfied. I guess that's my question, second question.
Okay, the sewer upgrades without question are done. The first one was done in March of 2018. The second was finished in December of 2019. Everybody agrees on that. The 5 reasons that the Planning and Zoning Commission gave was in May of 2020. They had nothing to do with the completion, with the upgrades of the system, which they acknowledged had been complete. They talked about sewer benefit assessments and consistency with the plan of conservation and development, none of which had been raised before. And I think that they violated administrative agency law, which says if you have reasons to deny a project, you have to put them out when if you can, when you first address the application, and you can't save them for later. But the Water Pollution Control Authority in July of 2020 did not adopt any of the Planning and Zoning Commission's May 2020 reasons. So I think in that sense, those have fallen by the wayside and are not before the court. I'm sorry, you're muted, Justice Khan.
Sorry. So what is before us? And I notice at least one other colleague has his hand up, so I will yield back to the chief. So what is actually preventing the project from going forward? And that's my last question.
Yes, the Water Pollution Control Authority has taken the position that since Summit Saugatuck did not appeal the Planning and Zoning Commission's negative 824 report to the town's legislative body and obtain a reversal, that the WPCA was prohibited from granting the sewer extension. That's the issue before the court, because the WPCA has conceded that all of its factual, substantive policy issues that were raised earlier in the case have now been resolved. And the reference in the record, page A435 and 437, are the Planning and Zoning Commission and WPCA 2020 actions, which, by the way, we did because the appellate court said you should reapply and see what happens. They expected the 824 issue to go away, and exactly that became the only reason for denial.
Thank you, counsel. I yield back to the chief.
Thank you, counsel. Thank you, Justice Khan. Justice Ecker.
Good morning, counsel. So my questions relate to 824 and 7246A. I guess my first question, and this may be unfair to you, but I'd ask you to the extent possible to answer it without reference to Fort Trumbull, because I'm just trying to get at the statutory sort of language and setup as opposed to what we said about it in the past. I understand your argument there. But so this is, the provision you're relying on, 7246A sub B, says that notwithstanding anything, an appeal can be taken from an action of the WPCA. So fine, but that doesn't mean you win the appeal. Right. It doesn't mean that the bases for the WPC's actions will be, found to be unjustified, obviously. So that still takes us back to 824. And, I have questions about Mr. Gelderman's argument there, but my question for you is, isn't your interpretation of that last couple sentences maybe, just pretty much wipes it out? I mean, it says pretty clearly here that if it's disapproved, then by the commission, Planning and Zoning Commission, then you need a 2/3 vote of the RTC. And so how do you deal with that? Again, putting one hand behind your back and not referencing Fort Trumbull.
Okay. The short answer, Justice Ecker, is that 824 is not and has never been conceived of as a permit vote. It is an advisory report process, and I'll give you a couple reasons for that. First is very important to Summit. If we had appealed the Planning and Zoning Commission's negative report to the RTM, while that was going on, our statutory appeal rights under 7246A would have expired. The timeframes are completely inconsistent, and that was been especially true in the summer of 2020 when the land use agencies were operating under the governor's pandemic orders. That might have been a strategic thing that the town of Westport was trying to do, was get us to appeal so our appeal rights from the WPCA would expire.
Well, maybe let me interrupt you there. I mean, I'm not sure you have a right to appeal from the RTM's.
I think it's
failure refusal, right?
It's agreed. We do not. There's no process for appeal from the RTM. So the PZC issues its negative report. It goes to the RTM, which is a political body, which has no standards for hearing and administrative record, decision criteria, no administrative or no expertise in sewer administration. And whatever they do, that's in the WPCA's view, that's the last word. And that just, we believe, has creates an absurd result in several ways. It makes the RTM review a plebiscite. It's contrary to the longstanding set of cases that say that land use decisions should not be submitted to a popular vote or referendum. Again, it's a political forum. It would contradict the legislature's explicit and exclusive delegation of sewer administration authority to water pollution control authorities. That's under 7245 and 246. It would allow Westport to evade both the Affordable Housing Statute and the Zoning Enabling Act. And finally, at least in Westport, it would violate 2 town ordinances because the RTM, the Representative Town Meeting, has delegated all authority that Westport has over sewers to the Water Pollution Control Authority. And here they want to take.
So I get your point that it doesn't make any sense, and Mr. Gelderman will, I'm sure, tell us why it does. But it appears to insulate the process from any kind of review at all. And if there's a negative report and the RTM doesn't give you the 2/3 vote, you lose, and that seems unworkable. But I'm just on the plain language of the statute. I mean, he's got a pretty good point just under the plain language of it, doesn't he?
Well, no, because Mr. Gelderman's argument makes 824 a permit vote with no standards, no hearing, no administrative record. And you asked me not to bring in Fort Trumbull, but at least the principle that action is unappealable. So the PZC could do anything it wants for any reason. Indeed, they did that in May 2020, and there would be no appeal. Let me answer your question a different way, Justice Ecker. It's important to remember that the 824 referral is always from the agency that has statutory authority to grant or deny the permit. And again, here I think I have to bring in Fort Trumbull. Fort Trumbull recognizes that the 824 process is subsumed in the permit process of the referring agency. So if we interpret 824 as a vote on a permit, then it doesn't make any sense because the agency with the authority to grant the permit is referring it to an agency that could essentially wipe out the process that it has just referred. Now, let me take one stab at a textual comment on 824. The confusing phrase in 824 is the words "the proposal," because it segues from a report on the proposal, and then it says, as you said, the proposal may be disapproved. The question, I think, is does the word proposal mean the proposed infrastructure improvement, or does it mean the advisory report about consistency with the plan of conservation and development, which is what historically an 824 report has been understood to mean. So if you look further down the statute, it says the proposal shall be adopted by the municipality. That is the language of adopting a report. We don't adopt a sewer extension, we adopt a report. So the way to make sense of the text of 824 is to read it to say the legislative body may override the advisory report of the Planning and Zoning Commission and then refer that back to the referring agency. But it makes no sense to read the second half of 824 as, in other words, if there's a negative report from the PZC, then the kicking it over to the legislative body becomes an up or down vote on the permit for the infrastructure itself. That is the absurd result that makes no sense. So I think if you read the second half of the statute as the RTM or the legislative body having the opportunity to overrule the advisory report, which then goes back to the referring agency, then it makes sense. And it perverts, and indeed, in this case, it harmonizes 824 with 7246A, and it's consistent with, there's not much legislative history on 824, but where it has been described, it is described only as a referral and comment process, never as a permit process and there's no case, there's no legislative history that would suggest otherwise. So I just want to.
That addresses the issue, and I'm sure we'll hear from Mr. Gelderman on it, but go ahead.
Okay, thank you. Thank you. I think I just covered all my 824 points in my response to, well, I just will say that with respect to the 824 argument, the WPCA's argument is that we should have followed the RTM appeal process, and that was just, for lack of a better phrase, a rabbit hole from which you would never emerge. And indeed, it has no standards for hearing administrative criteria or process. So we think the notwithstanding text controls. 824 supports that, and on the other side of the ledger, you just have absurd consequences. And the one thing I didn't mention is there is also a Westport town ordinance that is at, I believe, at A462 that says that review by an RTM review of the Planning and Zoning Commission shall not be construed to interfere with statutory appeal rights. That is a Westport Town ordinance, and that is exactly what WPCA is advocating in this case. So I think I've gone over all my 824 points, so I will turn to reversing the appellate court and somewhat going back to Justice Kahn's earlier question. The appellate court reversal of the trial court was based on the following determinations. Number one, that in April 2018 stipulation of facts about completion of the sewer upgrade and the availability of ample treatment capacity had not been included in the appeal record. The court said that sewer extensions and conditions of approval are always discretionary. The court said that an alleged unwritten policy against conditional approvals could be asserted, even though there was a written policy that said nothing about conditional approvals. And finally, based on those four things, the trial court had substituted its judgment for WPCA discretion. Perhaps the most important thing I can say in this argument is this. The trial court did not substitute its judgment for WPCA discretion. The appellate court misunderstood, I believe, that since 2016, the WPCA's denials of the extension have been based on their position that, one, Summit could not apply for the sewer extension before the upgrades were finished. They said the application was premature, and they also said that they had their 824 position. The WPCA has never objected to the physical sewer extension itself. No engineering basis, no technical basis. So the trial court did not substitute its judgment for WPCA discretion over extensions. It overruled the WPCA's what it thought to be a factually and legally unsupported denial of the extension and what it called the WPCA's nonsensical position on 824. So there wasn't a substitute of discretion with respect to the extension itself, and that's a really important point. Second, when, as you know from the record, the appellate court's decision to disregard the stipulation of facts was rectified by a motion for addressed by a motion for rectification. What that means is that the appellate court should have accepted in 2018 or 2019 as judicially admitted fact at trial that the upgrades were essentially complete as of mid-2018 and ample capacity was available. So that is a key fact or set of facts that was just missing from the appellate court's analysis because of their view of that the stipulation had not been made part of the appeal record. And by the way, I assume you've seen, we included the stipulation verbatim in our brief, which we thought was sufficient. We didn't put it in the appendix. Judge Schluger addressed that in the rectification. With regard to the sort of the lurking overarching issue here of sewer extensions being discretionary, yes, generally they are, but sewers are public utilities. If your land is in the so-called sewer service district, you have a right of access, and there's case law on that. But more importantly, or specifically in this case, under the case law, a sewer extension should be granted if four criteria are met. Number one, the property is in the town's sewer service area. Number two, there's ample capacity. Number three, there's no need to extend the sewer across private land, which would be a way to bootstrap or evade the town's sewer district limits. And finally, there's compliance with the written technical and engineering standards, or alternatively, there's no engineering or technical obstacle to the sewer extension. In this case, as of 2018, Summit met all of those criteria. On top of that, the area was zoned and designated in the Plan of Conservation and Development for development with sewers. And on top of that, 45 of 68 structures in this neighborhood are already connected to the sewer. 24 of those are multifamily uses. And so on that basis, we believe Judge Schluger correctly held that it was an abuse of discretion in 2018 to deny the extension. That now has been further amplified by the fact that the sewer upgrades are complete, and the WPCA has admitted it has therefore no policy basis regarding conditional approvals because the condition has been met. I'll just touch on this, the alleged unwritten policy against conditional approvals. And this involves the standard of review. The appellate court overruled the trial court's finding of fact that there was no evidence of any policy, which the trial court based on the fact that there was a written policy that contained nothing about conditional approvals. The public works director only testified he had never granted a conditional approval, but he had never been asked. So that, and third is the general case law policy that to invoke an unwritten policy, especially when there is a written one, invokes arbitrary action. So finally, as to reinstating the trial court approval, again, in its July 2020 denial, the WPCA has essentially withdrawn all its objections and bases other than its 824 position. So we believe the appellate court's bases for denial, for reversing the trial court have been superseded, and we would ask that the judgment be directed so that we can now proceed with our zoning application with the sewer in hand. That's all I have at this point, and I see my time is about to expire.
Thank you very much, counsel. Attorney Gelderman.
Thank you.
We can't hear you,
muted.
sir.
You're on mute, sir.
You've muted yourself. Thank you.
I must have clicked it twice. Twitchy fingers, I guess. But thank you, Chief Justice. I think the first point that I need to make is that Section 824 applies to municipal improvements. It's not an application process. It's not a permit process. It's a report process so that the Planning and Zoning Commission, acting in its planning capacity, can review municipal projects. And there's no question that an extension of a sewer is a municipal project, because this sewer will, even if it's not being paid for by the municipality, the sewer is an extension of the town's sewer system. And in Avalon Bay versus Milford Sewer Commission, for example, that was a similar situation where the applicant planned to pay for the sewer extension, and the court found that that is a municipal improvement. I'm sorry, Justice Hecker, I'm sorry. I see your hand.
Thank you. If I may, Chief, how is I mean, what's odd about what's odd about that construction? I see where you get it in the language of the statute, but is just it turns the WPCA determination, which I would think would be a technical determination. Sir, if you could mute yourself, we won't get feedback.
Me?
Yeah.
I don't know. I'm
Yes.
near the post road. I'm sorry.
No, just when you're, counsel, when you're not speaking, if you just mute when you're not speaking, it'll work. Trust me. Thank you.
It's a common. It happens all the time. So I mean, it's just so. I have two questions on that point. Just it's seems odd to me that it ends up being that a political decision, that is the decision of the RTM, is what governs, and it's the WPCA just says, yeah, we can't do anything about it. So that's weird. Another way to put it would be maybe the same question, maybe a different question, is there's no ability on the part of the applicant to obtain judicial redress from the RTM's decision, is there? Under your construction?
No, there isn't.
Isn't that sort of facially bizarre? I mean, just a prima facie bizarre that these folks would be absolutely blocked from going through with their project based on unreviewable political determination under the guise of being a WPCA ruling.
In a totally private situation where there was a private development, had nothing to do with the town of Westport, had nothing to do with its infrastructure and its sewer system, I would agree with that. But because this implicates the town's infrastructure, the town's sewer system, the town has a role. And the same concept applies to other municipal type improvements. For example, while the WPCA has control over sewers, the Board of Education has control over schools. Yet the Board of Education cannot build a school without going through the 8-24 process. And it's a multi-layered process that the legislature has set up. So it's not left solely to the WPCA, and it's not left solely to the Planning and Zoning Commission, because the RTM can override that decision.
If the town doesn't want a school because it doesn't want a school for policy reasons and so on and so forth, then I guess the town can make that decision, subject to whatever governing law is. But they wouldn't do it because on the basis of a sewer permit. They do it on the merits. That's what's weird here, is that it just seems. I mean, it's hard to overlook the fact that this is an affordable housing project, and one way or another, Westport has kept this affordable housing project out for, I don't know, what is it, 7 years now? I'm not suggesting bad faith or ulterior motive, but some of this, when you read the record, it's like, if one thing doesn't work, they go to the next. And I assume that after this process goes through, were this court completely hypothetically to say, no, 824 should be read like Mr. Hollister says, the town will go back and pick up on the 5 reasons that are contained in the report, and then those will be the basis for denial. And maybe sometime in 2040, we'll have a final answer. But you see the problem I'm pointing to?
I do understand it, Your Honor. Just so Your Honor understands the status, there actually has already been an application filed with the Planning and Zoning Commission, and as you probably predicted, it was denied. It's pending. There's an appeal pending on that already. It was not denied based on necessarily any of the 5 reasons that were set forth in the 8-24 report, however. But I understand how it appears that the P&Z has, in effect, veto power. But they render a report, and by the way, just so I don't lose this point, there's no appeal to the RTM. It's not an appeal process. The report is referred to the RTM, and I noticed that Summit in their brief claimed that it wasn't referred to the RTM. Actually, the document itself, the 8-24 report itself, in the CC section shows it being referred to the moderator of the RTM and to the Planning and Zoning chair, the committee chair for the RTM. But so it was referred to the RTM. It's not an appeal process. It's simply a second way that a municipal project can be approved. It's either you get a Planning and Zoning approval or you get an RTM approval with a 2/3 vote. Neither one of those things happened. Whether it was incumbent on the applicant to take the next step or not, he didn't. They didn't. So the RTM never had a chance to review this. And with respect to the written policy of the WPCA, the WPCA's written policy states specifically that you only come before them if you have a positive 8-24 report on a sewer extension. In this case, the applicant did things a little bit out of order, and the town accommodated that. This wasn't, we weren't attempting to keep the applicant away from the WPCA, even though it was out of order a little bit. Typically, the application doesn't even get made to the WPCA until after the Planning and Zoning Commission makes its report. And if it's negative, basically the policy, which is at Plaintiff's Appendix A457, says, following a positive report for the 8-24 application, the applicant shall submit a letter to the to the WPCA and basically make its application. So it's generally a prerequisite to even the WPCA hearing an application. That doesn't necessarily resolve your issue between the Planning and Zoning Commission and the WPCA. But I think that statutory scheme makes some sense. There are very few things in a town that get determined by one agency without input from other agencies. And in the case of municipal improvements, especially when it comes to infrastructure, those improvements are entitled to more consideration than just by the WPCA.
Thank you, Council. There's a question from Justice Khan.
Thank you. Sorry, Chief Justice.
Thank you, Chief Justice. Council, I guess my question is maybe a little too simplistic. There's a lot of history here, a lot of back and forth and applications and reapplications. At the end of your opponent's closing argument, in his first argument, he said all of the impediments, all of the issues that have been raised to keep this project from going forward are now gone. They have been resolved. You just indicated in response to a question by Justice Ecker that there has been yet another application since this appeal is filed, and that has been appealed as well. I'm just trying to get, I guess, a simple answer. If you can tell us, what is the current status? Have those issues been resolved? What is the impediment for this project to go forward? And if there is none, are we then being asked to give an advisory opinion?
Justice Khan, you may be being asked to give an advisory opinion on the issue of whether or not the conditional approval was appropriate. The original action, the original appeal from the action of the WPCA had to do with the fact that the remand from Judge Schluger indicated that the sewer extension should be approved if certain conditions were satisfied. Those conditions, as Attorney Hollister noted, have been satisfied at this point in time. Those are the conditions related to the sewer extension, the physical conditions. Just by way of a little history, where this sewer is proposed to be located the effluent flows into what's called a pump station, and then pushes it through a pipe underneath the Saugatuck River and eventually onto the water pollution control facility. So at the time of the application, the pipe under the Saugatuck River was being replaced and the pump station was being upgraded. Neither one of those things had occurred yet. So the WPCA said, well, we're not going to approve an extension without those things happening. And they eventually happened.
Right, and I understand that. I think I got that far. What I'm trying to understand now is what is the current impediment to this project going forward, and to determine whether is this now a moot appeal or not. Can you tell me what is the current impediment to this project going forward?
The fact that there is no sewer approval by virtue of the fact that there was a negative 8-24 report. That is one impediment. The second impediment is the administrative appeal that's pending right now on the application to construct the project. Even though a sewer extension had not been approved, the applicant filed an application for his development. So that was heard by the Planning and Zoning Commission over a number of public hearings, ultimately denied. That appeal is pending.
Is that denial also tied to the sewer system, or
No.
is it some other basis?
It wasn't, the sewer system was not, I don't believe, I don't have that decision sitting right in front of me, Justice Khan, but that decision had more to do with fire safety and pedestrian issues. It didn't have to do with the sewer. That, I don't think, was one of the reasons of denial.
So I just understood you to say that the denial still exists because of the negative report, and the negative report comes from the sewer problem. So it isn't an advisory opinion then.
The sewer extension
Right.
is as a result of that. The project itself, for example, the Planning and Zoning Commission, if the project met all of its concerns with respect to public safety and all that stuff, they should have, and hopefully would have, granted a conditional approval of the 830G application. That would have been conditioned on the ultimate ability to construct its sewer. That's an appropriate condition for an 8-30G application. But whether or not the applicant can get that sewer extended and constructed is really the issue that's before you. The town's argument is it can't happen because the prerequisite, the conditions precedent to the WPCA being allowed to grant that extension have not been met. So even if the 830G application,
which are the favorable report,
which are the favorable reports,
and the favorable reports aren't coming because of, in part, the sewer issue. So I guess I'm stuck on which comes first, the chicken or the egg. It seems like a circular kind of argument. Am I wrong to look at it that way?
Well, I don't know if wrong, but I wouldn't look at it that way. I would say that it's not necessarily circular. It's one of the approvals that need to be obtained to ultimately build this project. They have to have a connection to the sewer, apparently, because they haven't proposed a project with an on-site sewage disposal system. So presumably their project requires an extension of the sewer to their project. So without that, they won't be able to build their project. But that's not really, part of the administrative process as far as the Planning and Zoning Commission was concerned. Remember, the Planning and Zoning Commission reviews this first in the context of writing its report under 824. Then it reviews the project. When it reviews the 824 application, it's reviewing whether or not that improvement should be made. Now, even though the 824 report is not appealable, and frankly, I don't think the contents of the 824 report are particularly relevant to this action. What's relevant is that it was a negative report, but in its report, the Planning and Zoning Commission cited several reasons that were consistent with a plan of conservation and development to deny the application. So at that time, it did not have an application pending before it. It did not have an application to construct a project before it. It had a referral from the WPCA to give their report as to whether the sewer should be extended.
So I guess I'm wrong to look at it this way, and maybe you can elucidate or clear up my confusion, but it feels a lot like they can't get a sewer extension because they can't get a favorable report, and they can't get a favorable report because they can't get a sewer extension. So,
well,
where is it going to break? Where is the log jam going to open up, if you will?
First of all, if ultimately the applicant cannot extend the sewer, then their project is in all likelihood undoable. It's a large project. It needs access to the sewer. So ultimately, the sewer may be the thing that would kill the project. But the report is a report. There was also an application that was denied. Those are separate things. The application was not denied because of the non-existence of access to the sewer. The application was denied for other reasons, and those reasons are on appeal. And we don't know what the trial court is going to do with that decision. But the sewer it's only important because this applicant has decided to locate his project in an area that's not serviced by the sewer. So it's required, and he has to get it. But it's a municipal sewer, so it goes beyond just by the statute, goes beyond just the WPCA because it's a municipal improvement. I don't know if anybody's hands was up, but let me just, a couple of things I just want to, I think, talk about basically. And I think this, Justice Kahn, may be part of the confusion. The report by the Planning and Zoning Commission under 824 is not an action on a permit. It's not a permit. It's not an administrative hearing. It's not part of the permit process. It's part of the public improvement process, but not part of the permit process. So,
with the chief's permission, if I may, no one else has a hand up. With the chief's permission, I get your point. It's not part of a process, or it's not part of a permit, but it's functioning like a permit because it's functioning like a block to the project. Or am I, that I think that's the problem. And your opponent's saying not only is it functioning like a block, they have no mechanism to appeal that if it's treated like a permit. Can you answer that? And I'm that's my last.
Thank you, Justice Kahn. I don't disagree with that. I don't disagree with that. The effect of a negative 8-24 report that is not reversed by the legislative body has the ultimate effect of blocking this project because this project needs a municipal sewer to be successful. And the town of Westport gets to decide where its infrastructure goes and where it doesn't go. And the process is that it's not just the WPCA when it's a municipal improvement, it's the Planning and Zoning Commission, and ultimately could be the RTM if the Planning and Zoning Commission renders a negative report. So it can be characterized in a lot of different ways, but the statutory scheme ultimately can lead to a negative 8-24 report being a block. That says that the town, through its Planning and Zoning Commission and ultimately the RTM, has decided not to extend its sewer system, the town's sewer system.
Justin McDonald.
Thank you, Chief. Council, looking at 8-24, subsection 3, I know it's not relevant to this case per se, but it talks about no municipal agency can locate any development, right? I mean, just picking the words out, locate any development unless there's a Planning and Zoning Commission report. If the Planning and Zoning Commission says no, it has to go to the legislative body for any development in the town. Does that make sense?
No, and I don't think that's the reading of it, Your Honor. That development refers to public housing as opposed to any development. The RTM does, the Planning and Zoning
Commission. I don't know if it does. I mean, it says locate or extend any public housing. That's what you're talking about. And then comma, development, redevelopment, or urban renewal project.
Yes.
So an urban renewal project isn't necessarily public housing. And under your reading of that, it could go into a ditch without the legislative body acting as the ultimate land use authority in all cases. Is that incorrect?
Well, the 824 covers a lot of different things. So I suppose if it, I don't think it covers private development, but even if it did, I think the statute's plain language says that this is, it is a municipal improvement. That development has to be proposed by a municipal agency. That's how the 824 starts. So anything that a municipal agency proposes is subject to this review and report process. So if a municipal agency proposed private development on public land, it would go to the Planning and Zoning Commission through Section 8-24. So yeah, it applies to all kinds of different public improvements, but the improvements have to be related to in this case, a municipality. It may be other things. Public agency could be more than a municipality, but it's limited to those kind of improvements. So, and I think in a way it's a nod to the ability of towns to make decisions with respect to their infrastructure and their buildings and the location of their schools and the location of their playgrounds. You know, it's a nod to the town's ability to have input with respect to those things, and it's not being left to one single agency to make that call.
So your argument is that the word public is a adjective or a modifier for each of the items listed in subsection 3.
Well, I don't know if it's a modifier to each thing, but the no public agency is a modifier, because I can't foresee of a situation where a municipality is acting as a private developer, doing private development. I don't think that's even within the municipality's authority under the municipal powers, which I used to know what that was, 7-140, I think.
Thank you.
So I see I still have a little bit more time left, but the other thing that I just wanted to focus on briefly is the connection between zoning and Section 8-24. There really is no connection. The town is not required, the Planning and Zoning Commission, even when it's a combined Planning and Zoning Commission, is not obligated to review its own zoning regulations when it issues its 8-24 report. So regardless of what this property is zoned, is ultimately irrelevant in terms of its planning function when it's reviewing the town plan of development, the POCD, and making its recommendation to the legislative body. And again, while I understand that there's no appeal from the issuance of a negative report to court, where there's no judicial review of that, there's no judicial review. I mentioned this briefly in my brief. There's no judicial review of many actions taken by, for example, the legislative body. The legislative body appropriates money, among other things. There's no review of that because that involves appropriation of municipal funds for a municipal purpose, and that municipal purpose is basically up to the local legislative and administrative bodies. So there are things that are not subject to appeal to the courts.
Do you know of any municipality that has that type of restriction on a sanitary sewer system?
The type of restriction
of not having an avenue to have court review?
Well, there's an avenue for a denial under the WPCA provisions. Nobody can deny that. That's a statutory right of appeal from a decision by the WPCA. The WPCA didn't write the report. The WPCA is not the legislative body. In fact, the WPCA is the agency that goes before the Planning and Zoning Commission typically, and the RTM, if they have a project that they want to perform. They can't do it. They couldn't do their own project without those approvals. And there is a statutory right of appeal from any action of the WPCA with respect to sewer decisions. The fact that we're here today, I think, indicates that there is an appeal right there from that decision.
Thank you. Anything further, Council? Oh,
no,
sorry.
I saw Justice Secker's hand up.
Thank you, Council.
Thank you very much. Sorry to be a repeat player here. It occurred to me, I think it was in connection with the Chief Justice Robinson's question. And you may not know the answer to this, maybe it's not in the record, but you're very experienced in this area. Are you aware of any other situations in Westport when there's been, for example, a private subdivision development with a bunch of nice, fancy McMansion kind of houses, and there's a need for a sewer extension for the subdivision? where where there's been a denial or a obstacle of this nature. That is where there's no 824 approval, or the RTM doesn't do the 2/3 vote.
I don't know what you mean about McMansions in Westport, Your Honor, but anyway, no, I'm kidding about that.
No, I shouldn't have said that. I know they're not allowed. But nice, a private subdivision
Right.
with big houses and stuff.
No, the answer is I am not aware of any situation like that. I'm aware of situations where private developers have been denied the ability to extend sewers based on, for example, the exact reason that this was initially denied, and that was the work on other parts of the infrastructure. And I think I'm good. Thank you. I'll cede my 1 minute to Tim because I can see him, moving around over there. I know he has stuff to say.
But he won't get your 1 minute. But other than that, he can use his remainder of his time.
I will thank you. I will stipulate that was a magnanimous but somewhat empty gesture. In response to Justice Ecker's question, what is in the record, at least reflected in the record, Westport has a defined mapped sewer service district. It's called the Blue Line. It is illustrated in the Plan of Conservation and Development. And the historic record here, without exception, to my knowledge, is if you're in the Blue Line and you apply for a sewer connection or extension, you get it. And if you're out of it, you don't. And this land is unquestionably within the sewer service district. I know of no other instance where land within the Blue Line has been denied sewer. Mr. Gelderman said, and I addressed this in my reply brief, well, yes, we have a right under 7246A to appeal, but I think the WPCA's position is it's a rather empty right if you go through the 824 process and you don't come out with a positive report because it's unappealable. Let me go back to Justice Kahn's question. It's very simple: no sewer, no development. And you're not being asked to give an advisory opinion, because if we lose this case, we are nowhere. We're building at most single-family homes, market rate single-family homes on 1 acre lots or half-acre lots, but certainly not affordable housing. Now, I think Justice Kahn, I can untangle one point of confusion. The Planning and Zoning Commission's denial was in September of 2019. At that point, we were still operating under the trial court's May 2018 decision, which approved the sewer extension. So the Planning and Zoning Commission did not cite sewer or lack of sewer as a denial reason. The appellate court decision was a month later. Since the appellate court decision, we are facing a total block on the development for lack of a sewer approval. So without reversal of the appellate court decision, we are nowhere. So that I just wanted to clarify that. You asked, how do we open the logjam? We open the logjam by treating 824 as an appeal and comment process, and then allowing an appeal from the substantive decision of the Planning and Zoning of the Water Pollution Control Authority. Justice McDonald asked about the public housing. I think reading public as the modifier is the correct way, but I would point out that the key point here is 7246A deals with 3 specific types of sewer applications, and that is essentially the carve out from 824 that we are dealing with here. So 824, broad, sprawling, covers the waterfront literally and figuratively, but 7246A is specific to sewer. Let me finish just by using 2 questions to Mr. Gelderman that I think illustrate what the issue is in this case. Mr. Gelderman said that the 824 process, quote, implicates the town's sewer system, unquote. Well, not in this case, because the Water Pollution Control Authority's historic position was that Summit could not apply until the upgrades were done. That has been satisfied. That is off the table. So we're left with a process objection. There is no objection. There has never been a concern on the part of the Westport Water Pollution Control Authority about the capacity of its system or engineering or technical issues. So this in a substantive, real-world sense, this case does not affect or implicate the town sewer system. And finally, I'll go back to Justice Ecker's colloquy with Mr. Gelderman about the school. If you accept the WPCA's decision, the Board of Education wants to build a new school. They refer it to the Planning and Zoning Commission, which issues a negative report, which either is not reversed or goes to the RTM and is affirmed in its negativity. The 824 process has now just defeated the statutory authority of the Board of Education to locate a school. That is a good parallel to this case, and it illustrates what's wrong with the town's position. I have nothing further. Thank you, Chief Justice and members of the court, for your time.
Thank you, counsel. There is a question from Justice Khan.
Thank you, Chief. Counsel, my question is this, and I understand your position fully. At the end of the day, we're still left with being in the position of reviewing the appellate court's decision, reversing the trial court's decision. And it seems to me the trial court decision was favorable to your client, but it went a step further. Not only did it sustain your appeal, it specifically ordered or directed the approval of the sewer extension. Do you concede that to the extent that it was almost akin to a directed verdict, that it went too far? In other words, you could have received the relief that said, look, you cannot condition a denial based on a positive report without ordering the extension itself. Would you concede that?
If I understand your question, no. The trial court did not go too far because the trial court had in front of it a stipulation of fact that the upgrades had been completed. There was ample capacity in the system. And indeed, as we move forward in time to the appellate court, this case has essentially whittled down to the WPCA hanging its hat totally on its 824 position. There's no issue here about physical construction of the extension or discharge of sewer. So both at the trial court had a factual basis to order the conditional approval. The condition has been satisfied. The block now is one of process, and therefore my position that you don't have an advisory opinion before you. And of course, well, one other thing. Remember, of course, the appellate court did not address the 824 issue because they expected it to go away, but that turned out to be wrong. The 824 is now not only front and center, but indeed the appeal issue. Thank you,
counsel. Thank you, Chief.
Thank you, Justice Khan, and thank you, counsel. I want to thank both counsels for participating in this argument. When newer attorneys ask me, is oral argument important? I would love to put this argument up there, this kind of argument up there, to tell them exactly why it's important. Oral argument is extremely important, and we appreciate counsel being prepared and arguing this case. With that, thank you. Everybody be safe. I will see the justices in the virtual conference room, let's say at 12:15. 12:15, and we are in recess until tomorrow, 9:30.
Thank you, Your Honor.
Chief Justice.
You're welcome.